She should have kept it from last week because this is a returning one. What's this right here? Is this Udell? Let's see. Is that file for this?
David Alvin, 330 Ellen.
Okay. No, not Alvin, the guy that came back from jail, Brian Rice.
We'll call the case of Nicole Pollen versus Ryan Rice. And for the record, Mr. Rice is appearing via Zoom from the Monroe County Jail. Also present is Monroe County Front Attorney Rebecca Hicks. Ms. Hicks, good morning.
Morning, Your Honor.
Mr. Rice was before the court on Friday of last week. The court was informed he had a felony non-support charge pending. The matter was adjourned to today's date. The court recorded a $2,000 cash bond. Have you been able to determine what happened at the felony non-support arraignment late Friday?
Yes, Your Honor. He was arraigned and bond in that case was set at $2,663.97. So at this time, the friend of the court is requesting that we set aside our show cause, have no bond required on our case, and we will just resume enforcement upon adjudication of his felony non-support, as this is the underlying case.
Good morning, Mr. Rice. Do you understand all that?
Yes, I do, Your Honor.
Okay, will you be able to post a bond? Will your mother help you post that bond?
I believe so. I believe I can. I think I have about 1,000.
Well, it's 2,600, if I'm informed. So you're a little bit short.
Yeah. I think she'll help me with I think my mom will help me with the rest to get me out today, I hope.
Well, as long as come over to the front of the court and make sure they have your valid address and talk with your caseworker. If you're not working right now, file a motion to reduce support. Be proactive.
Yes, sir.
Okay, so in this civil action, we're simply going to, if you cancel the bench warrant, there'll be no bond required because you've got to post a bond in the criminal case. But so we will monitor the case and the progress in the criminal case. And then, of course, this file will remain open. And obviously, if you're not making significant progress in the county case toward your urges, then this court will bring you back here.
Okay.
So right now your support's what, $287 a month. If you can't afford that and unemployed, then file a motion to reduce support. Be proactive. Any questions, Mr. Rice?
No, Your Honor.
Anything further on Mr. Rice's case, Ms. Hicks?
Nothing further from the friend of the court, Your Honor.
Okay, all right, Mr. Rice, you can step out.
Thank you.
Matter Sarah Thomas versus David Alvin.
You, David Albane. Okay, you can have a seat there. Mr. Albane is appearing personally as directed by this court. He appeared before the court. Also present is appearing via Zoom as Monroe County Front of the Court Attorney Rebecca Hicks. Mr. Albane was brought before the court last week. He was ordered to appear today with 5 dealer estimates of his Harley Davidson motorcycle, which, if the court recalls, he purchased after selling some real estate. Is that correct? And he did not use any of the proceeds of that real estate to apply against his rearages. The rearages exceed $11,000. Is that all correct, Ms. Hicks?
That's correct, Your Honor. That's how we ended up with this finding of contempt and an order from you back in 2021 for him to list and sell the motorcycle.
And the court ordered him to sell it back in October 2021. Is that correct?
That is correct.
And that as of today, and we're almost October of 2024, 3 years later. Are you Sarah Thomas? No. Okay. What is your name? Okay. All right. Waiting for your attorney. No, you can sit there. Your attorney. All right. For the record, Mr. Albane has provided 1 Cyclocare 50-point inspection with attached to the card from River Rays and Power Sports. Looks like a technician examined it. And there's a figure down at the bottom of, I don't know what that, if that's a, what they're willing to pay for it, or it's a value of $13,805, Mr. Albane.
That's the.
Okay, what are they willing to pay you for it?
Pardon?
What are they willing to pay you for it?
They said.
Okay, where are the other 4 estimates?
I didn't get
Okay.
that.
All right.
My stomach dropped.
Okay.
It's all going to be the same, and that's.
You've not complied with any of this court's orders, Mr. Albane. So can someone pick up your motorcycle? Is it out in the parking lot? Can someone pick it up for you?
No.
Okay, all right. All right, you got 30 days hanging over your head. You know, you decide obviously to buy yourself 30 days. Ms. Six, what's your recommendation this morning? Clearly, Mr. Albane is ignoring this court. I don't know if we have the sheriff's department seize the motorcycle. We have that's additional cost that's going to reduce the value if we have a receiver appointed to sell that.
Right. We were trying to avoid that. We were trying to just have him sell it. If you're saying that the documentation he provided you is showing $13,805, that's greater than the total arrearage on the case.
Okay. All right.
So if he
court
would just sell it, he could have this
but obviously
case closed.
we need to obviously catch Mr. Albane's attention. That order still continues, Mr. Albane, but convince this court the court should not order you to serve 30 days in jail today. Then when you don't sell it, we're going to start over. Going to be a second fine, because not be up to 90 days. Okay. Convince the court why the court should not order you to serve 30 days in jail.
Your Honor, my son.
I don't want, sir, you're ordered to sell it. Nancy, can you please call for a pickup, please? Mr. Albane, I want to hear this. The garbage you're feeding the court, you're ordered to serve 30 days in Monroe County Jail.
Yes, sir.
And we'll get over there for lunch, and we're going to give him a date, surely maybe in about 45 days, Ms. Hicks, and we're going to put it on this court's docket, because if he has not sold it, we're going to start second finding of contempt. The court's going to reiterate, Mr. Albane, you are ordered to sell that motorcycle. So we're going to give you a couple weeks when you get out of jail to have sold that. What do you believe is reasonable period of time? Maybe see if he's going to serve 30 days out end of September, maybe mid-October.
Certainly.
Maybe your Mr. Leiter, Mr. Moss is back here, right there. If you want to, if you talk to them, you can talk to them on the hallway. Okay. Are you available on the 22nd or 23rd of October, Ms. Hicks?
Let me check. Yes, Your Honor, I'm available both days.
Okay. All right, we'll set it for Tuesday, October 22nd, 11:15 in the morning. Mr. Albane, you can appear by Zoom, and if you will start contempt proceedings, the plaintiff attorney to represent you on October 22nd if you've not sold the motorcycle and satisfy these rearages. And at that time, the second fine contempt will be up to 90 days. Yeah, you can avoid additional time if you have the motorcycle sold and you pay off these rearages. We will, did you want a copy of this? Got a copy? All right. Any questions, Mr. Albane?
Your Honor, for that order with the jail sentence of 30 days, are you going to give an amount that he could pay in lieu of serving that full 30 days?
What do you recommend? Yes, we'll give him an alternative to post a cash bond.
Give me one sec. I would say $3,000, Your Honor. That's a little less than 25% of his current arrears balance.
All right. Of course, that bond amount of $5,000 cash only. So you can serve 30 days. If you can post 5,000 cash, you can avoid the 30 days. You still got to sell the motorcycle. But if you want to be home for Labor Day, reach out to friends. They can post $5,000 cash. Will apply toward your rearages, not to fines and costs, but toward your rearages. And we will set another date, October 22nd, around 15. Review for the proceedings. They can come outside there. I'm sure they come to the window. Invites from River Power Sports to the file. The record again reflect that Mr. Albane has not complied with orders of this court regarding sale of the motorcycle or securing 5 estimates as to its value. I provided 1. Now just have them come outside door. Can you send you'll send an order over to the sheriff's department, correct? Regarding the jail
Yes, Your Honor,
funds?
I'm typing it up right now. And once I have it signed by you, I will be sending it over to them.
All right, very well, thank you. All right, sir. Mr. Albane, right here, we'll send an order over to jail. He's been sentenced to 30 days for contempt. So I trust he'll go over there in time for lunch. Thank you. And Ms. Hicks will email a copy of the order over to the jail. All right, Mr. Albane, get that motorcycle sold.
Calling the matter of Sarah Thomas versus David Albin.
For the record, this matter is before the court for post-judgment to review of the status of the defendant's efforts to sell a motorcycle and reduce outstanding spouses for arrearages. This hearing is being conducted via Zoom. Present the parties, Sarah Thomas and David Albin, as well as North Carolina Court Attorney Rebecca Hicks. Good morning, Ms. Hicks. Ms.
Morning, Your Honor.
Mr. Albin, Ms. Thomas. Ms. Hicks, have you had a chance to discuss these issues with the parties?
I have, Your Honor, and I did review the file to see that Mr. Albin has submitted additional documentation to his friend of the court caseworker regarding taking the motorcycle to multiple dealerships to try and get offers on it. He received 3 actual, I guess, cash offers, and the rest were only offering him like a trade-in value. They wouldn't offer him any cash value for that. And he also has it listed and lowered the listing price of it to just over what his total arrears are, and provided that.
Okay. What is the highest cash offer, Ms. Hicks?
$8,500.
Okay. Is Mr. Albin making any payments toward the?
Yes, after being released from the 30 days in jail, he did. They did give him his job back, and we do have an active income withholding notice to that employer.
What's the amount of the outstanding arrearages?
The total balance right now of the arrears on this case file are $11,530.92.
And they're being reduced per month by how much?
The income withholding notice has gone out for $351 based on the statutory limits on his case.
Right. So since we were last in court back in August, the arrears have been reduced by $350. The arrears were $11,800 back then.
He served 30 days in jail, Your Honor, and he just started resuming work.
All right, I understand now. All right, you have a recommendation for the court this morning, Ms. Hicks?
Your Honor, I did inquire, and Mr. Albin admitted that he's been driving the motorcycle. I do believe he should not be driving it, as it would be the position of the friend of the court that would diminish its value with each mile that is added onto its current mileage. The friend of the court would not be opposed to a short adjournment to allow him to pursue actually selling the bike to potentially one of these people that offered it, or see if he can get an offer for the lower amount that he sold it for.
All right. All right, the court here from the parties. Ms. Atkins, we'll hear from you first.
All right, thank you so much. Yeah, I think that's a good recommendation. He does drive the motorcycle. I've seen him driving it through town. I've seen it parked at his job before. So I think, yeah, he shouldn't be driving it anymore also.
All right. Any objection to a short adjournment of this matter?
No.
All right. All right, Mr. Albin, again, obviously this is pretty significant arrearage. It's $11,500. You should not be driving the vehicle. Why should this court not order you to sell for $8,500? You got an offer, a cash offer for that.
Your Honor, the bike is Blue Book value is around 14, with only 11,000 trade in. $8,500 seems a little low. I mean, I understand they're in the business to make money. I just thought if I got to take like $4,000 or $5,000 less than what the bike is actually worth, is there any way that Sarah could maybe lower what is owed to her by a little bit, just to kind of counterbalance the? So I did lower the bike to 12,000 stuff, 2,000 less than Blue Book. Fox is selling the same Fox and Sandusky is selling the same motorcycle with 5,000 more miles on it for 14,000. So I lowered this bike to 12,000. But it seemed like a fair price according to Brian at the Motown Harley.
Are you advertising on Facebook and other media sources?
Yes, Your Honor.
Well, again, obviously the time sell is in the summertime. And here it's, we're going into October, so obviously no one's, people are not gonna get the top dollar for a motorcycle in the month of October and November, Mr. Alban. Do you have another vehicle that you can go to and from work with?
Yes.
Okay, again, convince this court that you should not have to sell it for $8,500 and you can sell it this week.
Convince the court that I'm making payments.
That's
But
not the
I
question,
think-
sir, but you're not, again, you're only reducing reversals by $300 a month.
I think that's every 2 weeks, and I have $116 deductions. I have another case that I only owe like $2,600 more on, as far as that, and then I still owe state arrears.
Well, this court's not a collection agent, Mr. Alban. Ms. Six, again, there's no way this court, even if the court orders Mr. Alban not to operate it, there's no way this court can monitor that.
Okay, I'm lost for words, Your Honor.
Well, Mr. Alban, again, you get 30 days in jail. You didn't do what the court wanted in the past. I'm just really tired of dealing with this matter. Again, the sixth way to do it is sell it for $8,500 and you put that right toward the rearages. Why? You need to convince this court that should not be ordered this morning, Mr. Alban. Unless Mr. Atkins says, Judge, hold off. That's what the court's inclined to do.
I since like 2019, I've been given consistent payments, other than when I lost my job at Circle K and went to another job. I've tried not to miss any payments up until I think it was December or January last year of 23, and then I've been trying to make consistent payments at 116 a week since like 2018, 2019, and then
Mr. Alban, but going back, of course, you sold an asset and you generated significant cash, and you went out and spent it or hid it or bought a motorcycle rather than pay your arrearages. Ms. Atkins, do you want to ask this court to give Mr. Alban more time, or do you want it sold and liquidated this week?
I would like it sold and liquidated, honestly. Yeah. It's just been so long, so.
Court agrees. It's gone on too long, and Ms. Hicks, the court will order that Mr. Alban sell that vehicle forthwith. I'm going to have you come back in 2 weeks, Mr. Alban, and I expect you will pay I want to see a sales receipt, and that entire proceeds will be paid to the front of the court towards the arrearages. So I'm going to put it off for 2 weeks. You're ordered to sell the motorcycle for the best you can do, and that's it. Whether it's $8,500, $8,000, $9,000, you got 2 weeks to sell it, and then the court can order that to be sold. And if you don't, we're going to start contempt proceedings when you come back in 2 weeks. If it's not been sold, you've not provided a copy of the sales receipt and paid 100% of that to the arrearages. We're going to put this back on the court's docket. It's not going to be worth any more come spring. And there's no way the court can monitor Mr. Alban parking this vehicle and put it in storage. Give him 3 weeks.
So then we can do 11, 12, and 9:30.
How about November 12th at 9:30?
Okay.
I'll give you 3 weeks, Mr. Alban.
okay, thank you, Your Honor.
That
All right.
with your schedule, Ms. Six?
Yes, absolutely, Your Honor.
Okay, so this matter is adjourned to November 12th at 9:30 via Zoom. Ms. Six, is it possible you could prepare an order for the court?
I will, Your Honor, and I'll make sure to include your Zoom ID on it.
Okay, thank you. So the party, the matter should come back before the court for review November 12th at 9:30. In the interim, Mr. Alban is ordered to sell the motorcycle in question and provide it to the front of the court before November 12th, the receipts showing the proceeds received and from who purchased the vehicle and name and address of the purchaser, Mr. Alban, and the court would expect that 100% of those proceeds will be applied toward these arrearages.
Yes, Your Honor.
You get more than 8,500, but then if you don't do that, then the court's going to start contempt proceedings. Which will be punishable up to 45 days in jail at that time, and we'll at that time appoint an attorney to represent you and go from there. Any questions, Mr. Alban?
No, Your Honor.
All right, Ms. Atkins, any questions?
No, Your Honor.
Okay, all right, the copies will be mailed to you November 12th at 9:30. All right, that will conclude this matter. We'll see everyone then.
Thank you.
Ms. Six.
I'll get that order up.
This matter is before the court to continue to show cause hearing directed to the defendant, David Alban. The court ordered back on October 22nd that Mr. Alban sell his motorcycle, provide the front of the court with a copy of the bill of sale receipt, and pay toward the outstanding child support arrearages the entire sale proceeds from that motorcycle. This hearing is being conducted via Zoom. It appears that we have Mr. Albin present, as well as the plaintiff, Sarah Adkins, and Monroe County front of the court attorney, Rebecca Hicks. Good morning, everyone.
Good morning. Your
Morning, Your
Have
Honor.
you received the documentation from Mr. Albin regarding the sale of the motorcycle?
I have not, Your Honor. Mr. Albin said he was not able to sell the motorcycle as his son has the title and was not giving it to him.
All right, Mr. Albin, the court is ordering you personally appear. We're gonna start contempt proceedings over again. Yeah, Mr. Albin previously exhausted his 45 days, so this would be a second contempt proceeding, punishable up to 90 days. Is that correct?
That is correct, Your Honor.
All right, Mr. Albin, why don't you give me a cell number so the attorney can call you? I'm going to order you personally appear tomorrow at 11:15. And bring a toothbrush, Mr. Albin, because there's a really good chance you're going to spend 90 days in jail unless you have that motorcycle sold. You're playing games with the court, Mr. Albin. The court will not tolerate that. So what's your cell phone number?
My cell phone number is 73.
Okay. You understand you're being charged with civil contempt of court for which is punishable as a second offense, punishable up to 90 days in jail. And because of that, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Are you asking for a court-appointed attorney?
Yes, Your Honor. I can't get legal advice from anybody. I mean,
Okay. Are you currently employed, Mr. Albin?
yes, I am.
With whom?
Burger King.
Do you have any income other than your employment through Burger King?
Not really. If you know, I go clean toilets and stock shelves over at the party store that I used to work for.
Do you own this home on Michigan Avenue?
Yes, I do, Your Honor.
Okay, did you ever consider getting a home equity loan? You don't want to sell a motorcycle and get a home equity loan.
It's not my house.
I'm sorry?
It's not my house.
Oh, I thought you said you owned the home.
No. I sold the house. That's why I'm in this mess. And I didn't
Okay.
give it. I'm sorry.
So you're just leasing this home?
I live with my girlfriend.
Okay.
Your Honor, I've been reaching out to my son and stuff, and now reality's setting in. I need the title, and he's calling me every name in the book and how could I do this, blah, blah, blah. And I got it in text. I got, I'm really trying. I spoke to an attorney a while back, and I can't afford an attorney.
We're appointing an attorney for you, Mr. Albin, and the attorney's going to contact you by your cell phone number.
Okay.
Do you think you can, again, the question to move on this week, it really doesn't matter. You're not going to be able to sell that. Even if you get the title, you're not going to be able to sell that quickly. Why don't you sell it to your son? But it's got to be, of course, at the appraised value.
The appraised value is almost $14,000. They offer me $8,500 at the local dealership. It's sitting in the garage here on Michigan Avenue with the keys ready to go. If you want me to drop it off somewhere right now, I would do that. Wherever you need that bike, I'm having a hard time getting that title.
Son, Mr. Albin, he's playing games. You tell me your son, does he know you're going to go to jail for 90 days?
Yeah, I told him.
You're going to spend Thanksgiving and Christmas and through the balance of the year, Mr. I'm telling you, right, Mr. Albin. So, is it better than tomorrow? What day is better? Miss Hicks, what's better for your schedule? Tomorrow or Thursday?
Either one is fine, Your Honor.
All right.
Are you attending a conference on Thursday this week?
That's correct. The ICLA conference is on Thursday. How about we do it on Friday? We'll give Mr. Albin plenty of a chance to talk with his attorney and get that motorcycle sold and get that title from his son. So we'll set this for Friday then.
Okay.
The court is not going to the ICLA conference on Friday because it's only half day, Ms. Hicks. Will you be available on Friday?
I am, Your Honor. I'm available.
Okay, the conference on Thursday is really the crux of it. Thursday it's only till 12, and it's a long drive for just a couple of hours.
Absolutely.
All right, so we will set this. We'll set it for Friday then, which is November 15th. You were to personally appear, Mr. Albin.
I will, Your Honor.
That's Friday, November 15th, 11:15 a.m. Who is paying the insurance on the motorcycle? You or your son? You're the one that's using it, driving it.
I have drove. Yes, it's in my son and his plates and everything. he keeps it over here. He don't have room. He's half the time he's in Florida, and so.
Well, call him and let him know you're gonna spend the rest of this year in jail if you don't sell that. So you got to move quickly.
Yes, Your Honor. I've been honestly, I've been texting him, and it's coming down to a deadline, and now he's just playing. He's not returning my calls. I just keep, I kind of
don't buy it, Mr. Albin. Don't buy it. Don't buy it. That your son's going to ignore your. You gave him the motorcycle. In event, we'll see it Friday 11:15. Another option, you want to sell it? Come up with a significant sum. Bring in $15,000 on Friday. May avoid some jail time. All right. So anything further this morning, Ms. Hicks?
Nothing further, Your Honor. I'm just preparing that order. I'll get it in your queue shortly.
And the arrearages, what about, it's about $11,000. Is that correct, Ms. Hicks?
That's correct, Your Honor. A little over.
Has Mr. Albin made any recent payments?
Yes, we are getting payments from income withholding from his employer currently.
Okay. And if the court recalls there's history on this, Mr. Albin sold a piece of real estate, and rather than paying that toward his sport arrearages, he purchased a motorcycle. Is that correct?
That is correct, Your Honor. This motorcycle was purchased with the proceeds from the sale of that home.
And we've been reviewing this for what, the last 6 months?
He was ordered to pay this to sell this motorcycle in October of 2021, Your Honor. It's been 3 years.
Okay.
In that time, we had been getting payments from income withholding and reviewing his sale, but now that it's been 3 years and we've learned that he's driving it and continuing to diminish its value, and he doesn't seem to be very forthcoming in his willingness to actually sell it as ordered by this court, is why we ended up here with this new push for that.
All right, Mr. Albin, the court's granting your request for an attorney. You'll hear from the attorney. Your cell number, is that correct?
That is correct, Your Honor.
Okay. Ms. Atkins, do you have any questions?
No, I do not, Your Honor.
Okay. Is this son that Mr. Albin's referred to, is that a son in common, or is that a son from Mr. Albin, a prior relationship?
It is he is from our relationship, Your Honor.
Okay.
My son.
Do you have any contact with a relationship with him, Ms. Atkins?
No, he's not had a relationship with my son since he was about 2 years old.
What about you? I mean, do you have a relationship with him?
Oh, yes, I do, Your Honor.
Okay. Okay, well, I'll leave it to you whether you want to reach out to him to cooperate with his dad. That's Mr. David's problem. All right, this matter is adjourned then to Friday, November 15th, 11:15 a.m. You need to personally appear, Mr. Albin. We're on the 4th floor.
Yes, Your Honor.
Okay, that will conclude here, and you can all zoom out.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. The record, Mr. Moss has appeared personally as directed by this court last week. Also present is court appointed attorney Timothy Leiter, and appearing via Zoom this morning is Monroe County Court Attorney Rebecca Hicks. Ms. Hicks, it appears Mr. Moss has provided the court a copy of a receipt where he indicated he paid $1,500 for his arrearages this morning.
Yes, Your Honor. I see that in our computer system as well.
And I think the court suggested that. Mr. Leiter, have you had an opportunity to discuss with Mr. Moss these proceedings?
Your Honor, I've had a chance.
No, had a review down the road. Take supplement that.
All right, thank you. Ms. Hicks, what's the recommendation if Mr. Moss admits to contempt this morning?
That the friend of the court would not be asking for any immediate jail time, Your Honor. We would request that we put this out for a 2-month adjournment so we can monitor payments on the case, as well as the results of the motion that Mr. Moss filed to modify his child support.
Well, good. I'm glad he's taken some positive action in terms of filing the motion to reduce his support, as well as making a significant payment toward his arrearages this morning. Mr. Moss, are you satisfied you received your right to legal counsel by conferring with Mr. Leiter? Yes. Okay. Is it true that you wish to admit to contempt this morning, in which case the court would you'd have 45 days over your head, but the court would hand you the key to that jail. You would not spend time in jail unless you failed to comply with the reasonable request of this court. Understood? Is that what you wish to do? All right, raise your right hand to be sworn. Do you solemnly swear affirm that the testimony about giving this matter will be the truth, the whole truth, nothing but the truth, so help you God? Please state your name and current mailing address for the record. Ms. Six.
Your Honor, I did not. Can you have them turn the microphone towards
Yes.
them? When it's facing
One
away,
second.
it breaks up. I apologize.
We should always keep those turned around. Is there some reason why we don't?
Now I have it.
All right. Mr. Moss, you admit and acknowledge that you are obligated to pay child support for the maintenance of children born to you and Tiffany Budell. You admit and acknowledge that prior to today's payment, you had the arrears in excess of $5,000. You admit and acknowledge you've not been making regular monthly payments. Ms. Six, do you have any questions?
I have no additional questions, Your Honor.
Mr. Leiter, do you have any questions, Mr. Moss?
None, Your Honor.
Well, based upon the review of the court file as well as the testimony of Mr. Moss, the court finds there's a lack of due diligence on the part of Mr. Moss in addressing these obligations. He has a significant monthly obligation. He's finally filed a motion to reduce that child support in the amount that he can afford to pay. The fact that his arrears in excess of $5,000 suggests there's a lack of due diligence on the part of Mr. Moss in addressing this obligation. According to this court finds Mr. Moss being contempt of court for failing to comply with the support order of this court. And it is the intent of the court to impose a suspended jail sentence. Mr. Moss, is there anything you would like to say before the court imposes a sentence? Mr. Leiter, anything further?
No, Your Honor, we
Well, the court will order that Mr. Moss serve 45 days in the North County Jail, but to suspend that sentence at this point in time and schedule this matter for a review, sometime in October, Ms. Six, what date do you recommend?
October 29th at 10 a.m.
Okay, Mr. Moss, you ordered to appear before Ms. Six. Now, for this court, Mr. Leiter is relieved of his obligation at this time. If in fact you made no payments between now and October 9th, we'll reappoint Mr. Leiter because you're probably buying yourself some jail time, but you hold the key to the jail. You can avoid any jail time by simply keeping contact with the front of the court, doing your best. But appear before May 6th, October 29th, 10 o'clock. You can appear via Zoom from Lincoln Park. And hopefully she will not bring you before this court on that date. Anything further this morning, Ms. Hicks?
Nothing further from the front of the court on this matter.
Thank you, Mr. Leiter, for your assistance.
thank you.
Mr. Moss, you're good to go. Ms. Hicks will mail you a copy of this order with that date and time. You can appear via Zoom. Okay. Thank you. You as well. Thank you, Mr. Leiter.
Thank you, Your Honor. That's fine. Flipped up here since I got her. It's like,
Take this down.
Goldman's coming to look at it, and I came back up, and you guys went. I'm like, they're not on the record, are they?
I mean, Goldman can wait. I mean,
What's that?
Goldman can wait.
Right.
She told me to take it down. But he said he'd be here before lunch. I said, okay, I'll run it down.
For the record, this matter is before the court for a continued pretrial conference subsequent to the parties having engaged in mediation this morning with Mr. Josh Walker from the front of the court. This hearing is being conducted via Zoom. Present is Attorney Ronald Bruce, representing the plaintiff Michael McClellan. Ms. McClellan appears to be present. In addition, Attorney Matt Vidito is present representing the defendant Cameron McClellan. Ms. McClellan appears to be present. Good morning, everyone.
Morning.
Morning.
The court has been informed that the parties have reached their own agreement resolution on all standing issues this morning. Is that correct, Mr. Bruce?
Yes, Judge.
Does it also address Mr. Vidito's motion to modify parenting time? That was also discussed and resolved?
Yes.
Wonderful. Who would like to place agreement on the record?
I can.
Please, Mr. Bruce.
Judge, parties have two minor children, Chloe and Caroline. Parties will share joint legal custody and joint physical custody. Parenting time will be the 2-2-3 schedule. Mom will have every Monday and Tuesday. Dad will have every Wednesday and Thursday. Parties to alternate their balance of the week. The child support is to be $532 a month, which is $475 base, $57 ordinary medical. That's to commence after the marital home is sold. Starting on September 1st, my client will pay $400 a month in child support until that time. During parenting time, any guns would remain in a gun safe while the children are present. There should be no alcohol or drug use amongst the parties when they're exercising parenting time, or any supervisor who is watching the kids. In regards to that child support order from the defendant, that would be withdrawn. My client would be withdrawing the ex parte order that was previously entered. There was a PPO filed in Ohio that was actually dismissed, but there is a show cause hearing. I believe the defendant is agreeing to withdraw that. There is a marital home that has already been listed for sale. Proceeds for that will be used to pay the marital bills, namely 2 credit cards, one from Synchrony Bank, the other one from Navy Federal Credit Union. Any other proceeds, if there are any, to be split 50-50 amongst the parties. If the proceeds do not cover those credit cards, my client will be responsible for any remaining balance on those. No spousal support to either party, judge forever barred. Both parties have relocated to Marion, Ohio. I think they're in agreement that the domicile will be the state of Ohio for purposes of the minor children. There are no retirement accounts. Personal property is to be divided by agreement, with the exception of the defendant wanted a book collection, some Christmas bulbs, and I believe a Christmas tree. Bank accounts, my client would be awarded the Navy Federal Credit Union account and the Huntington account. Defendant would be awarded a Premier Bank checking account. Tax, for purposes of tax exemptions, my client would be ordered the exemptions for Caroline. The defendant would be ordered the exemptions for Chloe. She would like her maiden name restored, that being McBee, MCBEE. And daycare is to be split 50-50. And I think that's everything.
Thank you, Mr. Bruce. Mr. Vitito, did Mr. Bruce accurately state your client's agreement?
I think there's a few additions, Your Honor. One with regard to parenting time, they would be using the Monroe County front of the court holiday schedule with 2 exceptions. One is that Mr. McClellan would receive every 4th of July and Ms. McClellan would receive every Halloween. Other than that, it would be the front of the court holiday schedule as written. Both parties are agreeing to set aside the ex parte order that was entered by this court. They're going to cooperate to remove my client's name from the joint bank account. There is no retirement or life insurance. With regard to the child support, the responsibility for medical expenses, extraordinary medical expenses, is 75% paid by plaintiff, 25% paid by defendant, and that $532 a month would commence the first of the month following closing on the sale of the home. They were agreeing that my client would receive the Christmas decorations and her book collection, and any other personal property is going to be divided as agreed. The clarification is that the during parenting time, Mr. McClellan is agreeing to keep the firearms locked in a gun safe, not just in the gun safe, but locked in the gun safe. And I believe that is all the terms and conditions. Oh wait, no, I apologize. He's going to keep his Jeep Grand Cherokee and the Ram 1500, and she's going to keep her Jeep Renegade, and they're each keeping the debt thereon. And that's it.
Thank you. Mr. Bruce, are those clarifications acceptable?
Yes. What was her car?
Jeep Renegade. I think it's a 2021, I think.
They're agreeable, Judge.
Right, thank you. Right, Mr. McClellan, can you both please raise your right hand to be sworn, please? Mr. McClellan, please.
Mr. McClellan, do you recall coming to my office having a complaint for divorce filed in this case?
Yes.
And at that time, you did live in the state of Michigan, County Monroe, for 10 days, correct?
Yes.
And 2 children born of the marriage, Chloe and Caroline, correct?
Yes.
Your wife, to your knowledge, is not currently pregnant, correct?
Not to my knowledge.
And you believe there's been a breakdown of your marriage such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that your marriage can be preserved?
No, I don't believe it can be preserved.
Okay. And you wouldn't reconcile, get back together with your wife if the judge weren't to grant you a divorce, would you?
No.
I think the 6 months, Judge, is up on September
11th. Yeah, just a couple weeks.
We would ask the court to consider waiving that. Mr. McClellan, do you believe it's in your children's best interest to waive the 6-month statutory waiting period?
Yes.
You believe your kids would benefit from having some finality in this divorce, correct?
Yes.
And you're asking the court to waive that 6 months, right?
Yes.
You heard the terms of the divorce. You don't have any questions in regards to that?
No.
And you're asking the court to adopt that as your final judgment of divorce, right?
Yes.
Nothing further, Judge. Thank you.
Thank you, Mr. Bruce. Mr. Vidal, do you have any questions, first of all, from Mr. McClellan?
Just 2 questions, Your Honor. Mr. McClellan, have you disclosed all of your assets to my client during the pendency of this divorce matter?
Yes.
Have you hidden any assets?
No.
No further questions.
Thank you, Mr. Vidal. Questions for Ms. McClellan, please.
Yes, thank you. Ms. McClellan, you've heard the terms of the agreement that have been placed on the record.
Yes.
You're asking the court to adopt those.
Yes.
You believe that they're in the best interests of Chloe and Caroline?
Yes.
With regard to the mediator was neutral during mediation, right?
Yes.
He didn't take sides?
No.
Okay. Now the parenting time provisions, you heard that placed on the record, and all the provisions were stated accurately, right?
Yes.
And you didn't, with regard to that agreement, you weren't forced into that agreement by anyone?
No.
You're doing it of your own free will?
Yes.
Okay, and you've heard the testimony of Mr. McClellan on the record. Do you believe that he's being truthful?
Yes.
Okay. Are you currently pregnant?
No.
Are you satisfied with my representation?
Yes.
Okay, I have no further questions. Oh, wait, I'm sorry, one other question. You've heard that Mr. Bruce stated on the record that spousal support is forever barred. You understand that you can't come back at a later date and ask for spousal support, right?
Yes.
Okay, it's forever closed, that issue.
Yep.
All right, no further questions, Your Honor.
Thank you, Mr. Vidal. Mr. Bruce, do you have any questions of Ms. McClellan?
No, Judge.
You'll prepare the judgment, Mr. Bruce, is that correct?
I will.
Of course, the court recognized that the statutory 6-month waiting period is just in a couple weeks, so the court will in fact enter the judgment of divorce upon the presentment. Court would like to thank Mr. Walker for his assistance this morning, as well as, of course, attorneys Bruce and Vidal for helping facilitate ample resolution between the parties. The court would applaud you, Mr. McClellan, for reaching your own agreement. Without question, the best resolution is one in which you both participate. Far better off to have the court make these decisions. Based, however, on the testimony that's been presented this morning, as well as claim filed this case, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, is ordered upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting divorce from bonds of matrimony. Good luck to both of you. Keep in mind, need to make it good for each other and your two children. There will be challenges in life, but they can all be addressed through effective communication. So make it good. All right, with that, good luck to both of you. That time evaluation, is that correct, Ms. Gorski?
Yes.
Is that correct, Ms. Coonan and Mr. Chappell?
Yes.
Okay.
And with the court's permission, Judge, I'll place that agreement on the record.
Please, Mr. Godfrey.
Thank you, Judge. We have one minor child, May 2019. Temporarily, and pending further order of the court, and without prejudice, the parties would share joint legal and joint physical custody of their daughter. Dr. Wooten has been trying to get a report to everybody for, I'm pushing probably eight months, and it has not come in yet. And the parties would stipulate and agree that Dr. Wooten's report would be sufficient for any party to seek a change in parenting time custody, and that neither party is prevented from bringing up matters or actions or acts that they think is important that predates this agreement. So if they want to go back 2 years, 3 years, they can bring up anything they want involving parenting time custody, obviously subject to what weight the court gives it. But Dr. Wooten's report we just don't have, and frankly, Judge, I'm tired of waiting for it, so we're going to go forward with what we've got. Is that sufficient, everybody, that for making a record on this, Ms. Kuhn?
Yeah, it constitutes proper cause or a change in circumstances. That's fine.
All right. Ms. Zagorski, do you think that we've covered it enough?
I do. Thank you.
All right.
So, Mr. Godfrey, in the interim, the parties will continue to share joint legal, joint physical custody, correct?
That is correct, Judge.
All right. Thank you.
All right. Parenting time by the parties is a 2-2-3 parenting time schedule, broken down as follows. Week 1, father would have Monday, Tuesday. Mother would have Wednesday, Thursday. Father would have Friday, Saturday, and Sunday. Week 2, mother would have Monday, Tuesday, father Wednesday, Thursday, mother Friday, Saturday, and Sunday. This schedule would continue. The parties would utilize the Monroe County Friend of the Court holiday schedule absent a contrary agreement of the parties. For tax exemption purposes, the parties would share the minor child with mother claiming even years and father in odd. This would ultimately be a part of the child support provision of the judgment of divorce and therefore subject to modification by the court. Health insurance coverage for the child. Mother would continue to maintain health insurance coverage for the benefit of the minor child, so long as the same is available at a reasonable cost. Reasonable cost is defined as 6% of a party's gross income. When mother has the coverage, father need not obtain it. I was using, for purposes of the child support formula, a cost of $462 to cover the cost allocated for the child. Any uninsured medical expense would be split 80% by mother, 20% by father, after father pays the first $454 per year of uninsured medical expense. For purposes of the child support formula, it is $828 for the base support. Health insurance premium adjustment is $97, and then the ordinary medical care amount, I will figure that out, but it's going to be it so that we come up with the $753 total. And what I do, Judge, on this, I run it with two different methods, one with the mother claiming the child, and the following year with father claiming the child. That comes up with two different child support amounts. I add those up, divide by 2, and that's where the 753 comes. And I'll just fluctuate the ordinary medical amount to come up with the 753. One year it's 744 to father, and the other year it's 761 to father. So I just take that average and came up with the 753. Any questions by the parties so far?
No.
Yes. The exemptions, that's tax year and not calendar year, correct?
That is, it would be even year, calendar year for the tax year that, so in 2024, mother would claim, even though the tax return is filed in April of 2025.
Okay, so it is not tax year, it's calendar year.
Calendar year. Well, it would be the 2020
Oh, it's tax.
taxes
It's
are
tax.
filed in 2025.
Okay, and my other question was regarding vacation time.
Hopefully we will have that resolved, but before next summer, after Dr. Wooten's, I did not get into, unless the parties want to agree, 1 week each month during the summer.
A week.
Each month. I thought we continue. Can we just continue on with what we have in place until we get Dr. Wooten's report?
Yeah, that's
Thank
fine.
you.
That's
2
fine.
weeks, 2 weeks non-consecutive.
Yep.
Okay, yep, that's fine.
Whatever notice, and then whatever notice there was, whatever we had, I mean, it sounds like we're operating off of it anyway, probably with the exchange time, with the way that they're,
Yeah, whatever they have been doing would continue
okay, so that the prior order, we're just gonna kind of take and put it into this, correct?
into the judgment.
Perfect, okay.
All right.
Thank you.
As to extracurricular activities, if the parties agree to an extracurricular activity, that cost would be shared 50-50 by the parties. If they do not agree, then the parent that enrolled the child in that activity would be responsible for its cost. The child is in preschool, and that would continue at Stony Creek Preschool. No decision has been made on school for 2025-2026 school year. So this is through preschool right now, so the child would stay in the young fives in 2024. The parties would be utilizing the app close device for communication concerning their child, and this should be used for all communications. The calendar for the child, or the calendar on the app close device, should also be utilized so that the parties can be kept abreast of any doctor's appointments or extracurricular activities, school activities, things of that nature. Child support, mother would be paying to father the sum of $753 per month commencing September 1st of that 2024. And as in the amount that I indicated, that would a uniform child support order would enter. Anything else involving the child?
Yeah, with the extracurricular activities, if the parties don't agree, does the parent who doesn't agree, do they have to transport the child?
Not unless it's a school-related activity.
Okay.
If it is not school-related, they do not have to take the child to that activity.
And Mr. Gaffer, I think we also agreed that the parties would enable, under the app close system, they would enable the ability to make calls on that program as well.
Yes, calls, video, whatever app close will allow. You can do video chat or snap, whatever they can do so that a parent can communicate with a child.
Okay, thank you.
All right. In other words, we're not restricting any part of the app close. I mean, the calendar is going to be there, communication, audio, video, whatever they can utilize to keep abreast with the child. Then we go to real estate. There's one parcel that is clearly marital, and that's one that property is only in mother's wife's name, and the mortgage is only in wife's name. Wife would receive that property as her sole and separate property, and there will be a cash settlement that I will discuss infra judge, but mother will receive that. She will have to pay that cash by December 31st of 2024. If that is not paid by that date, the house would be sold. The proceeds, net proceeds would be split 50-50. Any capital gains issues upon the sale or tax consequences from the sale would also be shared 50-50. I'm hoping we don't have to get there. Mother is pretty confident that she could come up with the cash, which I guess I'll say now is $310,000. And that cash would be paid by December 31st of 2024. If for any reason that does not occur and the house goes up for sale, it's the net proceeds that are going to be divided 50-50. But we're not going to parcel out what might be owed to wife's mother or what might be owed to father's mother, each of which puts some money into this house. And there's differing amounts, but it's just going to be split 50-50, whatever that may be, if it has to be sold. If the parties had any interest or husband had any interest in the property at 9, that is kept by husband as his. As to this property, wife is, as to the one she was awarded, wife would hold husband harmless from any past, present, or future obligations concerning the property. There is, on this property, there was rentals out for the summer. It's on Crystal Lake. Mother would be picking up all income on taxes that we'll talk about in a moment for this property on her return. If there's any sales tax issue, she's responsible for the sales taxes. As to the tax issue, the parties have had prepared a 2020, 2021, 2022, and 2023 tax returns, but they have not been filed. Each party would be filing for those years, married but separate. They can use whatever tax preparer they want to use. So if Leland Proshek, who is the current tax preparer, he should cooperate and give the report, the file to whatever tax preparer each party wants to use. And each party is responsible for their own taxes for the property that they are being awarded. They pick their own income up, and they pay their own taxes or receive their own refund. Automobiles, wife is awarded her automobile, and husband, if he has any, is awarded his. Wife's currently is a 2020 Subaru. Each party shall be responsible for the taxes or expenses, plates, insurance on the items that they have been awarded, and they would hold the other party harmless from any liability thereon. If I did not say it, I should, that as if there's any escrow balance on the Beulah property, that is awarded to wife. And I think there was some taxes paid as part of a mortgage payment, but that is awarded to wife.
Bill, does she also get, I think we also agree that she gets all of the tax credits associated with the.
Anything involving that property, she keeps. The liabilities, the credits, the escrow, and it has to hold husband harmless from any past, present, or future liabilities concerning that property. As to bank accounts or brokerage accounts, the parties would each keep their own. Specifically, wife had a TIAA brokerage account that was not retirement. She keeps that in a Vanguard brokerage account. Husband keeps his non-retirement accounts consisting of an American Funds, LPL Financial, and a Dearborn Federal Credit Union. There are some joint accounts. One is Ameritrade, which as of today's date had $1,904. That is to be split 50-50. Hopefully somebody can create a new account at Ameritrade and just roll that over so that each keeps half. PNC checking and a Premier money market were de minimis monies, but those are joint and would be divided 50-50. Somebody's got to go to the bank and just close those out and divide those sums. If either party had any other bank account that they may have in their name, they would keep that as their sole and separate property. As to retirement accounts, husband does not have any retirement. Wife does have retirement. Some of that was premarital, but for purposes of the settlement, all of wife's retirement accounts that she currently has are going to be treated as marital with a division date of December 31st of 2023. Wife would be entitled, or husband would be entitled to any gain or loss from that division date on that account. Any cost by Ann Pastrana to prepare the quadros would be shared equally by the parties. If there's any cost by the plan administrator to implement the quadros, that cost would be shared equally as well. Specifically, the accounts that are being divided is wife's University of Michigan 403B value. Well, it doesn't matter. The 403B, University of Michigan 403B supplemental retirement account, and a University of Michigan 401A. All of these are at TIAA Craft being managed there. I assume there's going to have to be 3 quad rows, but I'm not positive of that. But whatever is there as of December 31st of 2023, it's all marital and it's going to be divided 50-50 as of that date. Personal property, the parties intend to try to resolve their personal properties on their own division. If there is any dispute, I would ask that the parties request an arbitration by September 15th of 2024. If they request an arbitration, absent a contrary agreement of the parties, I would act as the binding arbitrator. The sole role of the court would be to enforce the award of the arbitrator. Unless the parties demanded, the arbitration would be without attorneys, and they would share that cost equally. I have already exchanged some personal property list. Hopefully the parties can go through that and identify really what is in dispute, and they won't need me. But again, I would give them to September 15th. Do the parties think they can accomplish the exchange by September 15th, or do they want to go a little longer?
We're fine with September 15th.
We'd prefer September 30.
I don't have a problem with doing September 30. That's just to figure out what they want to keep or exchange.
Is that agreeable, Ms. Kuhn, Mr. Chaplin?
Yeah, that's fine. That's fine, Judge.
September 30th, okay.
Yes.
Life insurance, each party would keep whatever life insurance that they may have, free and clear of any claim, title, or interest of the other party. Husband has a number of business interests, all of which are awarded to him. I identified those as Mansig Trucking LLC, Mansig Farm, and AIS Enterprises LLC. Husband is awarded those, free and clear of any claim, title, or interest of wife. Husband shall be responsible for any past, present, or future obligations or liabilities concerning those businesses. On husband's tax returns, which he is filing married but separate, he would be picking up any gains, losses, or profit or expenses in relation to those businesses on his return. Wife picks up everything dealing with the Beulah property as well as her income on her return. And the parties would use that even odd for claiming of the daughter during that period of time too. Even years mother, odd years father. The only caveat with the picking up of the expenses in relation to properties is if the house has to be sold up north of in Beulah, husband and would be picking up any capital gains, if any, as part of that sale. Marital debts, husband shows up on 4 debts that wife is going to be responsible for payment of. And the 4 debts that shows up on husband's credit report are as follows: a Capital One account ending in 3703, a Capital One account ending in 7626, and a PNC credit card, I believe it's a Visa, ending in 0703. Those 3 cards still have an outstanding balance. That outstanding balance is approximately $23,444. Wife shall be responsible for payment of that. She can close the accounts, stop those. Husband cannot charge on those. He was an authorized user. There is one other account with PHD, that's Tom Henry Dog, CBNA, that is a Home Depot Citibank account, I believe, ending in 4105. That has a 0 balance, and that one can be closed out. They were not closed out before, Judge, because there was an order indicating that they shouldn't be closing out or affecting that. So we didn't have that taken care of based upon prior order of the court. But wife can get husband's name off of those 4 accounts, close them out, and eliminate husband's responsibility for any part of those debts. As to all other credit cards that are non-joint, each keep their own, and they shall hold the other party harmless from any liability. Wife would hold husband harmless from any liability on those 4 accounts that I just mentioned, the 2 Capital Ones, the Citibank, and the PNC card. Any other debts that I have missed?
The only thing that I can see is that there was a representation made that there are no loans against the retirement accounts, correct?
That is a correct statement. There had been a loan, but that had been paid off prior to the divorce being filed.
Yep. The last loan is being paid off in 4 days, Bill.
All right. Okay.
No.
On the retirements?
Yes.
Okay. The health insurance for the parties, each party is responsible for their own health insurance coverage post-divorce at their own expense. If either party had incurred any medical procedure that was not covered by insurance, each party shall be solely responsible for payment of their own uninsured medical expense. Wife would keep her devout last name. She never took husband's surname. Attorney fees, each party is responsible for payment of their own attorney fees and costs. Spousal support is forever barred, and the cash payment due husband by wife is at $310,000. And that would be by December 31st of 2024, and the court would retain jurisdiction over all provisions dealing with the terms of the judgment. Husband would release the cell phone number and phone through AT&T forthwith, so wife would keep her cell number and phone. That needs to be accomplished forthwith. On the property items, the one thing the parties have agreed to, if I can find that sheet, is as follows. Kayaks that are up north would be awarded to wife. The kayaks that are here in Monroe County are awarded to husband. The parties would copy all of the photographs involving Maggie, the minor child, and they would share that cost. That would be done through Walgreens in the Dundee, Michigan location. As part of the judgment, the parties would enter into a mutual restraining order that neither party shall stalk, harass, molest, wound, or any similar type language that would go into the judgment. And I think I've already talked about the app close used by the parties for all purposes. I think that's the agreement, Judge, but I got a ton of notes here. I think I've got it.
Mr. Godfrey, once again, with respect to the Cone Road property in Maybe, that's awarded to the plaintiff husband, is that correct?
That is correct, Judge. Yeah, I mean, wife thinks he's got interest in it. He says he doesn't. I'm just saying if he had any interest in it, I think it is only via a trust that will kick in if his mother passes away. So, for purposes of the divorce, I'm just saying to eliminate any concern about that, that's awarded. Whatever interest the parties may have had in that, he keeps. It might be zero.
Thank you. Thank you, Mr. Godfrey. Farrell, Mr. Gorski, did Mr. Godfrey accurately state your client's agreement?
Yes. Thank you, Judge.
Thank you. Ms. Kuhn or Mr. Chappell, did Mr. Godfrey accurately state your client's agreement?
Yeah, he did, Your Honor, but we did want to specify that with respect to the cell phone, and I know this seems like a small issue, but we've had some controversy with it, that what's required is that Mr. Mansick will either call to let them know that the transfer can occur and that it's her account, or provide a PIN to Ms. DeVote so that she can effectuate the transfer. And we would ask, I know we said forthright, but we would ask that we could all agree, please, that be done in no less than 48 hours.
No controversy, Judge. In fact, we Googled how to do it today. He needs to get a PIN and he can do that in the next 48 hours.
Yes, sure.
Wonderful, thank you.
Okay, that was it, Your Honor.
All right, thank you. Mr. Mansick, Mr. DeVote, can you both please raise your right hand to be sworn, please?
Yes.
You both need to speak up so we can capture responses.
Yes.
Yes.
Thank you, thank you. All right, to Ms. Zagorski, if you want to begin with Mr. Mansick, please.
Yes, thank you. Would you please state, you can put your hand down. Would you please state your name for the record?
Mark Mansick.
And is it your testimony today that your marriage continues to be broken down and there's no likelihood that the marriage can be preserved?
I do.
And is it your testimony today that to the best of your knowledge, your wife is not pregnant?
Not that I know of.
Okay. And you heard the agreement that was stated by Mr. Godfrey?
I did.
You understand it?
I do.
You and I have been talking about this for, gosh, about 7 hours now, right?
Correct.
You understand all the terms and conditions?
I do.
And I know that you're not completely satisfied. Is that a fair statement?
True.
But you understand the math
I do.
and you're asking the court to adopt it.
Correct.
And you and I have talked a lot today about if we ask the judge to have a trial, that you could do better or worse, right?
Correct.
And you know those risks associated with going to trial and with agreeing to this today, correct?
Correct.
And with all of that having been discussed, you're asking the court to adopt this agreement?
That's correct.
Do you understand your obligations under this agreement?
I do.
You and I have talked about the tax consequences of this agreement. And is it fair to say that I have not given you any tax advice?
You have not.
And we've talked about the fact that I'm a lawyer, not an accountant, and that you needed to talk to your accountant, correct?
That's correct.
Okay. And you believe that, no, strike that. You understand that spousal support is forever barred.
Correct.
And you and I talked about the likelihood of you getting spousal support if we asked the judge to order it, right?
That's correct.
And that was contemplated when we came up with the final number that your soon-to-be ex-wife would pay you for your interest in the marital estate, right?
That's correct.
Do you have any questions?
I do not.
Have you disclosed all of your assets?
Yes.
Okay, thank you. That's all I have, Judge.
Thank you, Ms. Sikorsky. Ms. Kuhn or Mr. Chappell, do either of you have any questions for Mr. Mansick?
Just a few, Your Honor. Thank you. Mr. Mansick, relative to the spousal support being barred, I want to make sure you understand that this is a final order and that what that means is that the court, your understanding is that the court is not retaining jurisdiction over that issue. So this is done essentially forever. You cannot come back at any time for any reasons and ask for spousal support in the future. Is that your understanding?
It is.
Okay. Can you also confirm that with respect to the temporary nature of the joint legal and joint physical components of custody, that you also stipulate and agree that what we placed on the record is a temporary order? Is that correct?
Is that correct?
Okay.
I'm asking. I think he doesn't know because that calls for a legal conclusion.
Okay.
You stated it a different way.
Yeah, let me rephrase it. You understand we're all waiting for Dr. Wooten's report, correct?
I do understand that.
Okay, so if after Dr. Wooten's report comes out, we've agreed, and you agree with this, that essentially would be a change of circumstance, or I'll avoid the legal jargon, based upon what Dr. Wooten report provides. You agree that each of you have the ability to come to the court and request changes.
I understand.
Okay, or an evidentiary hearing on that.
That's where the judge would take testimony and we could call Dr. Wooten to testify about why he thinks whatever he thinks.
Right.
Okay, all right, thank you. That's all I had. You did.
Ms. Kuhn, do you have any questions of Mr. Mansick?
No.
All right, questions for Mr. Boot, please.
All right, can you state your full name for the record, please?
Rebecca DeVoe.
Okay, I think we've taken the proofs already on this case, Your Honor, but I'll just reiterate some of the questions. You've concurred that there's been a breakdown relative to the marriage relationship. It's irreconcilable and you're asking for a divorce and continue in that regard.
Yes.
Okay, can you confirm that you're not pregnant? It's a necessary question for us. Okay.
Yes.
You like,
No.
you are
Can you
not
just speak
pregnant.
up? Mr. Boot, you need to speak up. We're not capturing your responses. Are you currently pregnant?
No,
Okay,
Thank you.
yeah, speak, yeah, when you answer,
Voice
speak
up.
towards that so they can hear that.
sorry.
You likewise have participated in this mediation session for a long time today, correct?
Yes,
Do you understand all the terms of the agreement that have been placed on the record?
yes,
Do you also understand that you do have the right to go to trial and call witnesses, put evidence on, et cetera? And the court could make a determination as to what should happen with the things that we've agreed to resolve today.
yes,
But you're agreeing to, you're waiving those rights in light of this agreement.
correct.
Okay. And have you fully disclosed all your assets?
Yes,
Are you likewise, is it likewise your understanding that with respect to spousal support being barred, that with spousal support, that is forever resolved? You cannot come back to court and ask for any modification of that in the future. The court is not going to retain jurisdiction of that for any future involvement.
yes.
Okay. Do you have any questions that have not been answered as of this time?
No, I didn't.
Okay. Thank you.
Thank you, Mr. Chappell. Mr. Gorski, do you have any questions of Mr. Boot?
Just one. Was there a loan against your retirement as of December 31st, 2023?
No, I just did it for 2 months.
Okay, thank you. And then I did have a question, I guess, for counsel and Mr. Godfrey. We're agreeing that Maggie's play therapy is going to continue at this time, correct?
I did not say that, but that was my understanding.
Ms. Kuhn?
Yes.
Yes,
That's correct.
yes.
Yep.
Okay.
That she'll continue with the current therapist. Is that what you're asking for?
It shall
Play
continue
therapist.
play therapy as previously ordered, yes.
Yeah.
Okay, then that's all I had, Judge.
Thank
And
you,
we
Mr.
did not get a
Gorski.
letter from her as well, Judge. And one of the things that I was concerned about, apparently the play therapist said she would forward a letter to you. And I'm assuming if she did forward the letter to you, Your Honor, you would forward it on to the attorneys. I'm not sure why she won't send it directly to the attorneys, but at least at this point, there isn't a letter out there.
That's correct. When my client talked to her about her recommendations and communicating those, she indicated that she would only communicate directly with the court. I explained that the court would then share it with counsel, but to the best of our knowledge, there's been no communication so far.
Very well. And yes, the court has not received anything. Perhaps a friend of the court has, but the court is not aware of any communication from the therapist. But if the court is aware of one, the court will certainly forward it to counsel.
Thank you.
And who will prepare the judgment? Will you prepare that judgment, Mr. Gorski?
I will.
Very well. The court would like to thank Mr. Godfrey for his fine efforts and assistance this afternoon, as well as, of course, attorneys Zagorski, Kuhn, and Chappell. The court applauds you, Mr. Mancic and Ms. DeVoot, for reaching your own agreement. Without question, the best resolution is one in which you both participate, as you have today. Hopefully, you can continue that progress with respect to all issues involving your daughter, Maggie. You want your daughter to thrive, and she will if you're on the same page. As she gets older, she's going to sense when there's animosity and tension. So you need to always, in her eyes, respect the other parent. It's the little things that are important. Like dad always make sure you get her a card for mom for Mother's Day, and mom get her a card, or your daughter a card for dad for Father's Day. Those little things mean a lot to children. In that regard, the court did receive a certification that Mr. Boot completed the problem-solving workshop or the high conflict solutions workshop. The court received nothing from Mr. Mancic. Mr. Gorski, has he completed that program and written a statement?
He has completed the program. Did you write a statement?
I did. I'll forward it to you.
He'll forward it to me. I'll send it to the front of the court, Judge.
Thank you. I mean, forward to the court. The court's got the one from Mr. Wood. I'll make sure the front of the court has all of these.
Okay.
But hopefully the parties benefit from that program. That's all the court asks, is that two of you communicate effectively for Maggie's best interest. She's 4. It'll go quick, but you got a number of years you need to work together for her best interest. And I'm sure you both want her to succeed in life and have a healthy relationship with the other parent is critical. Based upon the testimony that's been presented today, as well as previously in the complaint filed this case, again, the court finds that jurisdiction has been established, that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reason likely that the marriage can be preserved. Clearly upon receipt of the judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce for bonds of matrimony. Thank you again, Mr. Godfrey. Good luck to you, Mr. Mancic and Mr. Voot. And now conclude the proceedings for today, and hopefully, when you receive Dr. Woon's report, you can come to your own terms in agreement with respect to your future raising of your daughter. So with that, everyone can zoom out and have a good rest of the afternoon.
Thank you,
Your Honor.
Judge.
Thank you, Judge.
For the record, this files in this court's, for this court in the absence of Judge Arnold. Currently, the parties engaged in mediation and wish to place an agreement upon the record. This hearing is being conducted via Zoom. President's Attorney John Finn, representing the plaintiff, Robert Duchesne. Is Mr. Duchesne present in your office, Mr. Finn?
Mr. Duchesne is on the telephone, Your Honor.
Okay. Mr. Duchesne, are you present on audio?
Yes, sir.
Good, thank you. Good afternoon. And also present is Attorney Amy Boskoviak, representing the plaintiff. I'm sorry, the defendant's mother, Emily Duchesne, and Ms. Duchesne is present with Ms. Boskoviak. Who would like to place agreement on the record?
I'm happy to do that, Your Honor.
Please, Ms. Boskoviak.
The parties are going to have joint legal custody. There'll be no statement of physical custody. The father will have parenting time, reasonable and liberal as the parties can agree. They've agreed that they will attempt to agree on holiday schedules, but if they cannot agree, then it will be according to the friend of the court schedule. There are 4 children, so for tax purposes, they'll each take 2 of the children. When there are only 3 children remaining, if it's an even year, the mother will take 2 children. If it's an odd year, the father will take 2 children. Again, when there's only 2 remaining, they'll each have 1. And then when only 1 remains, they'll use the same formula such that the mother will have even years and the father will have odd years. There is real property, a marital home. The mother's going to remain in the marital home, and it shall be her sole and separate property. Beginning September 1st, she shall begin paying the mortgage, utilities, and all expenses on the home. She shall have 12 months to refinance the house in her name, and if it's not, she's not able to do so, the property shall be sold. But in either case, the mother is entitled to all of the equity in the marital home. And the plaintiff shall cooperate to sign off any documents necessary in order to do that. He will sign a quitclaim deed to sign the title over to her. In exchange for her keeping the real property, the defendant has agreed that she will waive any interest in the plaintiff's 401k account for his employer at Ford. The parties will divide the personal property as they can agree. They've already divided a substantial portion of that, but to the extent that there's anything remaining, they will do that. Each party will take the debt in their own name. There is a joint HELOC debt, and Mr. Duchesne is going to take that debt. Since that debt is associated with the marital home, Mr. Duchesne will pay off that debt within 1 year so that that debt would not remain if the defendant was going to refinance the property. There are 2 vehicles. Mrs. Duchesne is going to keep the 2017 Dodge Caravan. Mr. Duchesne is going to keep the 2000 Explorer Sport Track. Those are both paid in full, and each party will cooperate to make sure that they are titled in their own name. To the extent that there is automobile insurance, at the time of the final decree of divorce, they would each be responsible for their own. Each party would keep their own bank accounts. There's a joint account, and Mrs. Duchesne is going to cooperate to take her name off the joint account. If she is not able to, then the parties will dissolve that account, and Mr. Duchesne would be able to keep the proceeds of that account. Mr. Duchesne also keeps his PNC account. Life insurance, there's an account at Western Mutual. They each have a life insurance with Western Mutual. They'll each keep their own account and name any beneficiaries as they wish. Mr. Duchesne is going to inquire as to whether he has life insurance at his employer, and if he does, he is going to agree to name his children as the beneficiaries on that account. Child support has already been calculated at $2,584, and that is going to continue in the same manner as it has been in place. And the uninsured medical expenses are going to continue at the same percentage. I'm looking for that order. I don't.
I believe it's 82 and 18.
Okay, 8218, thank you. Spousal support to Mrs. Duchesne from Mr. Duchesne starting September 1st at $416 a month. It is non-modifiable as to duration and amount. They each will pay their own attorney fees. She is going to keep her married name. There is one issue that they did not discuss. It was in a prior order, but I want to make sure that it gets continues over to this order, and that is that Mr. Duchesne agreed to pay for driver's education for the oldest child. So with that, I believe that's the entirety of the agreement.
Thank you, Mrs. Woskoviak. Mr. Finn, did Mr. Woskoviak accurately state your client's agreement?
Well, the only thing that that I think was the spousal support was 36 months, and I don't know. I really don't know what Mr. Duchesne says about the education, the driver's ed.
It was a prior order that he was already ordered to pay.
July 10th, 2024. There's an order in the court file that Judge Arnold ordered Mr. Duchesne to pay the driver's education for the oldest child.
I think that he's going to do that.
Okay, but the spousal support, do we have everyone on the same page for spousal support, 36 months?
Yes.
Non-modifiable in terms of amount as well as duration, is that correct?
Yes.
Yes.
All right. Well, Mr. Duchesne, can you both please raise your right hand to be sworn, please?
Mr. Duchesne, did you hear that everything that the court said, or that?
Yes, sir.
And do you agree with everything that they've said?
Yes.
And do you agree with the education, the driver's ed?
Yes.
Okay. And now, you could take this matter to trial, and you might get a better deal. You might get a worse deal. You might get the same deal. Is that correct?
Yes.
And you're in agreement with this, with what you have stated to the court. Is that correct? Or what Mrs. Woskoviak said to the court?
Yes.
Okay. And do you have any problems with what I have done?
No.
Okay. And do you have any issues that you need to raise to the court right now?
The child support that gets taken out of my check. Does that go, like, where does that go? She have something that's set up for her? Do I have to do something for that?
No, it'll go directly to the Michigan. I forget what they're called, but
okay, so that's already all set up for her.
It's all set up.
Okay, yeah, that's it. I don't have any other questions.
Okay, I have nothing further, Your Honor.
Okay, do you want to establish the jurisdictional proofs, please?
You want me to go ahead and do it?
Okay, that's fine, Ms. Woskoviak, please.
Thank you. State your name for the record.
Emily Duchesne.
And Emily, is it true that you were legally married to Mr. Duchesne on August 15th of 2008?
Yes.
And was it true that prior to him filing the complaint for divorce, that both of you were residents for the state of Michigan and the county of Monroe for 180 days preceding the filing?
Yes.
Is it true that there's a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that it can be preserved?
Yes.
I have to ask whether you're currently pregnant.
No.
There's 4 children born of the marriage. Is that correct?
Yes.
Now, as to you're asking the court to enter a final decree of divorce.
Yes.
Okay, so you heard the agreement that I read onto the record, correct?
Yes.
And that agreement was as a result of not just one mediation, but 2. And during that time, did you disclose all of your assets and liabilities?
Yes.
And do you understand the agreement that I read onto the record?
Yes.
Do you believe that that agreement that I read on the record was in fact the agreement that you want to enter into?
Yes.
Do you believe that that agreement is in the best interest of your children?
Yes.
And do you believe the agreement is fair and equitable?
Yes.
You understand that the spousal support, that you will receive spousal support and that that is non-modifiable?
Yes.
Do you have any questions for me?
No.
Do you have any questions for the court?
No.
Do you understand that we could have gone to trial and you might have done better, or you might have done worse, or you might have done the same, but you're asking the court to enter into this agreement?
Yes.
Do you want the court, once this is placed into writing, to make these terms into a final decree of divorce such that you will both be bound by this agreement?
Yes.
I don't have any other questions.
Thank you, Ms. Moskovak. Mr. Finn, do you have any questions on Ms. Duchesne?
No.
You'll prepare the judgment, Mr. Finn, is that correct?
Yes.
Okay, with this agreement, can the pretrial before Judge Arnold on Wednesday of this week, August 20th, can that be vacated?
Yes.
Certainly can, yes.
All right, we'll inform Judge Arnold of that. Finally, the court would like to thank Mr. Walker and acknowledge him for his fine assistance helping facilitate a resolution. And of course, also the court would like to acknowledge attorneys Finn and Moskovak for helping ample resolution. Based upon the testimony that's been presented, as well as plain filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. But calling upon the presentment of the consent judgment to Judge Arnold, he will sign that judgment, and at that time, he will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both you, Ms. Duchesne. That will conclude this proceeding. Everyone can zoom out. Have a good rest of the afternoon.
Thank you.
Thank you.
Thank you.
Welcome.